I've been in disability movement for quite a number of years. And may I say, in terms of describing myself, about colors, colors I'm told, I don't know. So today I'm told I am in a dark blue suit. I'm in a tie that is another shade of blue, and I am in a white shirt, and my shoes are black. My hair is a little white here and there, signifying my seniority. I think that's what I would like to say in introducing myself.
Thank you, Sam. If Sam is a senior, I think I'm a little bit of a junior, but in the senior level as well. I described myself yesterday. Let me begin with my name, K.I. Laibuta. I described myself yesterday, but for those who are not here, I am tall. Not too tall, but I'm tall enough. And today I'm not dressed formally. Today I decided not to put on a tie, but I'm in a blue shirt, a black blazer, black trousers. Yeah, there are those who talk of tops. Then I should say I have a blue top and a black bottom, if that is the language. Right. So let's kick off. There is a lot more we can say about ourselves, but our experiences in access to justice, advocacy, and policy change will be a little more enlightened even as you listen to the two of us. Why are we just the two of us? We had intended to have a wider panel, a few more in number than we are. But as it turned out, it is going to be a conversation between Sam and I. So just to kick us off, Sam, tell us, what standards have we on access to justice for persons with disabilities at the international level, even before it trickled down to the national and continental level?
Thank you very much. At international level, the whole question of access to justice has been greatly discussed. And this is because it's one of those areas of problem. About 4 years ago, the Office of the Human Rights Commission, working with the Committee on the Rights of Persons with Disabilities at the UN, in which I serve, and also at the leadership of some mandate we call UN Rapporteur on Persons with Disabilities. At that time, it was a lady called I've forgotten the name, I'll tell you in a minute, came up with guidelines relating to access to justice. Access to justice is one of the articles of the Convention on the Rights of Persons with Disabilities. And this issue was, as we observed in the Committee on the Rights of Persons with Disability, having issues in its implementation, in the implementation of that particular Article 13. And it became necessary for a whole study to be done as to what principles and guidelines should be put in place for states in order to adhere to this question. In the first place, there are 10 principles were developed, and I will briefly talk about these 10 principles, very, very briefly, because we don't have the time. And this is a document you could also access on the internet if you go to the CRPD committee website. The first principle is based even on another article, Article 12 of the Convention, which talks of legal capacity. And the whole question of access to justice is bound around the issue of legal capacity. Many countries have a problem with this, particularly with some disabilities, among them psychosocial disabilities and intellectual disabilities, where people are declared that they have no capacity to make decisions, they have no capacity to act on different issues, but the convention clearly talks of the legal capacity of everyone. Everyone has legal capacity, and here we are talking of legal capacity to act and legal capacity to exercise your jurisdiction, to exercise your will and your preference. And that has been put forward as one of the areas or principles to be observed. And we will need to revise a lot of our laws to get into that. In the first place, you find that even in a country like Kenya, the judge, like my friend here, will first want to see that you are examined as to whether you are in the right mind to stand trial. And a lot of people with psychosocial disability will fail that. A lot of them with intellectual disability will fail that. And what happens to them? They are sent to a psychiatric facility for treatment, as it is said, and for protection, as it is said. But they may languish there forever because they are there at the pressure of the president. And the president hardly ever remembers that there are people like those. So the issue of legal capacity and the fact that everybody should be treated like any other and be given an opportunity to defend themselves, to talk for themselves, is an issue. And many of our laws, particularly mental health laws, will need to be revised to reflect that. A number of countries have tried to do that, including Kenya, but we haven't done very well. The new law that is there still has discriminatory aspects. The second principle on access to justice looks at the accessibility of facilities. Our courts of law, our detention centers, and all other places where people are expected to go in search for justice. And I don't want to talk much about accessibility. Everybody is quite aware of accessibility because that affects every aspect of our lives. And so what we are saying is that the courts of law and all these places where we go to seek for justice need to be designed in a way that everybody is able to access. The third principle regards what we call procedural accommodation. And procedural accommodation is totally different from what we have talked about, accessibility. This is where we consider everybody and their needs. Do they need interpreters? Do they need support? Do they need help to stand trial? Do they need intermediaries? Do they need information in ways that are different from the usual? And this becomes quite an essential part of accessing justice. The fourth area is the way notices or regarding access to justice are given. Are they given in language that every person with a disability is able to understand, in formats that are accessible to them? Are they given in a way that they will reach people and they will be understandable to them? So the whole question of how do notices regarding access to justice reach people who need them, particularly people with diverse needs of communication. And the fifth area, the fifth principle, looks at safety. And safety here has to do with how are people with disabilities regarded before and after seeking justice. The question of how do the police treat people with disabilities? How do they treat a person who is deaf? How do we assure a person who does not communicate like other people, a stammerer who stammers before a policeman? How does that person get treated? How safe is he, even in the prison, in the remand where he is put? How can we ensure that these places are safe for our people with disabilities? The fifth area regards the whole question of legal assistance. Is legal assistance available to people with disabilities? Today in Kenya, we have a law on legal assistance, but is this normally accessible and easily obtainable by people with disabilities? Do the legal people appointed to assist understand disability themselves? Are people with disabilities capable of filing their own cases, and can they get, legal assistance in this regard? This is an area we can discuss the whole day, and we need to look at that. The other area that is considered is the whole question of information on the whole area of justice concerns. Are people with disabilities reachable by the information that goes in public newspapers and everywhere regarding how people can seek justice? This is another area of importance. And the other area of concern is an area that we have done fairly well, I would say, in Kenya. How are people with disabilities involved in the judicial processes, both as judges, as magistrates, as witnesses, as juries, and as people who are taking place from the opposite side of criminals in regard to justice issue? Have we, as a country, as a region, gotten into a position of saying that, yes, people with disabilities are participating, they are there? Of course, we know they are there, like Justice Dr. Laibuta here, but how many are they, and when did we begin to see them? Well, this is Kenya. What is happening elsewhere? That is another area of big concern. Another area of concern in regard to justice is the whole question of monitoring of the rights of persons with disabilities, the whole question of discrimination, the whole question of equality and non-discrimination. Who is monitoring this? We are aware that the Kenya National Commission on Human Rights is supposed to do this, but does it give report, especially on specific areas of how people with disability are accessing justice? Are people with disabilities involved in this as provided for in Article 33 of the Convention on the Rights of Persons with Disabilities? The other area regarding access to justice, and it's the last that I'm going to mention, has to do with the issues of awareness raising. Today, a lot of people with disabilities will be said they cannot stand trial, we cannot take their witness because they are this way or the other. The whole question of whether they can be arrested or whether they can demand justice on their own, these are areas that even our judges, our magistrates are not quite clear about. And here we are talking of the whole question of awareness. Awareness on the part of persons with disabilities themselves that they have rights and they should exercise those rights. The whole question of those who live with them, be they parents or other carers, to know that when people with disabilities have their rights violated, they can go to court, they can be defended in court. This awareness is lacking. And these are some of the things that we are saying our government will need to address. Thank you, Dr. Laibuta.
So you begin to see how our diversity in the disability sector impacts our ability to access justice. And of course, the issue of access to justice is a very broad issue. We have sufficient laws, we have UN standards for the promotion and protection of disability rights or rights of persons with disabilities. In Kenya here, we have a constitution, just as we have constitutions in the rest of Africa. We have legislation that spells out the rights, and we have judicial institutions where people with disabilities would then pursue enforcement and protection of their rights. However, a lot of this could be just law, legal frameworks, institutional frameworks. But the gaps are very wide when you sit down to think it over and consider how accessible that justice system is for persons with disabilities. As we speak today, I am sure, I don't know whether I am aware of one of our delegates here is following through with yet another team of parents who have children with intellectual disability being locked up in prisons or in custody for months on end, if not years, because they are unable to speak for themselves. They are apprehended in the streets. They probably are caught up in situations that suggest that they are in the process of committing a crime and they're locked up. And when they go to court, they are committed to mental institutions. How do we get about this big problem of ensuring that they have access to a judicial process that is sensitive to their special needs? And that is a big conversation. So access to justice, broad as it is, efforts have been made to ensure that legal assistance, if I'm to speak for Kenya, is availed through the legal aid, networks and under the Legal Aid Act. And when we start to formulate the legal aid rules and regulations, we're quite conscious of the fact that persons with disabilities stood as a priority group for legal assistance, because a lot of them wouldn't be able to stand for themselves. And we were conscious of the fact as well that it is not just the burden of the relatives, the parents, the siblings, and the close relatives at home that were obligated to foot their legal bills, because this is a national burden that we should all carry. So there is a great deal to talk about access to justice. Beyond just the legal framework and all that, there is a great deal more that we need to address ourselves to. So Sam, I don't know whether you have anything to say about the legal frameworks, how they can be made inclusive. What experience have you had with those frameworks that exist for accessing justice, how can they be made inclusive for persons with disabilities?
Thank you very much. We have moved from where we were, and I think we can say that we are moving. We are not where we ought to be, but one of the things that I would say, we have a number of registrations, as you have outlined, but one of the problems that we are having is that even the little registrations that we have, including the convention itself, because it is part of our laws in as far as Kenya is concerned, having been ratified by Kenya, we have these documents. But the last thing I talked about here is the question of awareness raising. Even now, the people who administer the legal assistance in Kenya are not aware that people with disabilities need to be included in that. But I can say we are moving because we are having people like Dr. Laibuta here who have studied law. We are also having a class of younger lawyers with disabilities who are starting to help us and to make us to be a little more litigative. And we need to follow up on this, and the legal framework that we have is adequate. I'll give you an example of 2 or 3 examples in Kenya. There was, not long ago, a young lady, well, not quite young, a lady who was working with a round company as a salesperson. And she happened to lose sight. She happened to be losing her sight and could not use the computer in its normal, ordinary formation. And she learned how to use a screen reader. And she went to the employer and said, if you put a screen reader on my computer, I'll be able to continue to do my job. But the employer, when he heard that what the screen reader does is to speak to you, he says, no, we can't do that because it will speak to everybody in the office. So the lady was eventually dismissed. And this lady brought the case to court on the basis of what we call reasonable accommodation in the convention. And we had people, like the gentleman was mentioned, one of the blind lawyers who went to testify in the court and went with all his gadgets and the way they speak and the way they can just speak to you. And the court agreed that the lady had been discriminated on the basis of disability, and she was given an award. So what we need to do is to utilize even the legislation and the policies we already have. We learn to use them, and we need, of course, to be more educated. I said when I talked of awareness, it's not only on the part of the judicial process, but it is also on our own part to know where we can go to court and win cases. I am also aware, still on this country, somebody who was discriminated, he does an interview online. They don't know he has a disability, and he passes the interview. When he appears for the job, he is told, we didn't know you are like this. And so the person went to court. And again, he won the case. He was properly awarded. So we can do things. Of course, you can also fail. Some years ago, here in Kenya, we wanted to take the government to court because there were 12 seats in parliament which were said to be for marginalized people. That was just before this constitution we have now of 2010. And we looked at the people who were nominated, and we said, no, people with disabilities are marginalized, and they are a big group they should also have been nominated. So we say we need to go to court. We tried to go to court, but when we went to a lawyer, he asked us for 5 million Kenya shillings. And I'm talking of nearly 20 years ago. 5 million Kenya shillings to take up our case. Of course, we gave up. So I'm saying we have moved, and what we need to do, Dr. Laibuta, is first of all to make use of the legal framework that is already there, make use of the guidelines such as been provided for by the UN, and use international experience on what is happening elsewhere. Thank you.
And the beauty of it is that our own legislation for the promotion and protection of disability rights does adopt the UN Convention on the Rights of Persons with Disabilities to the letter. And therefore, we're not really lacking on legislation. There is legal aid, of course. Information has been a problem. And that is why we do not just talk about accessibility. We need to talk about meaningful accessibility, meaningful access to justice that takes account of the diversity of the special needs that we all enjoy. And that requires heightened advocacy activities. And the main challenges that we face today is that there are fewer, much fewer than there ought to be, opportunities that give room for meaningful advocacy. Just so that people get to learn, first of all, what disability is all about, what are the special needs that need to be addressed, what are the measures of intervention, what resource levels need to be committed, or budgetary allocations that need to be committed, who should take up those commitments, and together ensure that justice is accessed. And there are many things we need to talk about when we talk about access to justice. The right to human dignity. How do we treat persons with disabilities out there? Is it a tokenism approach to service provision, or do we provide services and give meaning to the rights that enjoy protection under the Constitution in such a way that we do not discriminate? The right to equality and freedom from discrimination is pivotal to our daily lives. To what extent do we enforce them? What Sam has talked about discrimination here is real. I remember in 2009, I had been listed for appointment by the president as a judge of the High Court. And when I wasn't aware. And when that list went to the then Minister for Justice, he crossed that name and said, we cannot have a blind judge. I don't know what he would say now with a judge who is blind in the Court of Appeal, not the High Court. And this has happened to quite a number of us on several occasions. We usually don't go to court because, again, some of us believe in one door closing, 10 opening behind you, and all you need to do is turn around and walk through a door of your choice. Our rights and freedoms are not alienable. Neither are they donated. We earn them. They must be protected. However, we also need to heighten our advocacy levels just so that we are able to reach out to those who do not understand disability. And if you want to know how people do not understand disability, and many of you here who are blind or visually impaired will bear me witness. You go to a restaurant with your guide, You sit, you order a meal, you pay, and your guide is given the change. Or even before you are served, very often my assistant is asked, huyu atakula nini? You know?
That happened to me this afternoon.
Atakula nini? Usually what I do is I keep quiet, and then he says, muulize. And then I say, but chief, si umeulizwa swali ujibu. You know? And they suddenly realize that I make my choices. But the mental attitude out there is discriminatory, in violation of the right to human dignity, in violation of the freedom from discrimination. So at the end of the day, maybe Sam, you can tell us, what should we do to influence policy change? Because besides having these rights spelled out in legislation, we also need to adopt policies that work for us, that are not just documents gathering dust in shelves. We really need to have the apposite policies that drive the show for promotion and protection of disability rights. Over to you, Sam.
Thank you very much. Just before I say what really needed to be done, may I say that although I have said we have a framework, a legal framework adequate to really support our access to justice, there is need for us to continue advocating for change of laws towards this area of non-discrimination. And I say this because we do have a number of laws that are contradicting each other, and I'm going to give you an example. The County Government Act, we have 47 governments other than the main government in Kenya, for those who are not Kenyans, provide that an assembly of the county must have persons with disabilities. Even the Constitution is, in fact, the County Government Act says that any assembly that does not have a representation of women, youth, and persons with a disability is not duly constituted. And today we have about 21 counties where there is no representation of persons with disabilities. Why? Because we have another law, Elections Act, which says that when the Independent and Electoral Boundaries Committee receives a party list, they cannot change. And the party list, people are told to put 8 people in a party list, and then the Election Act, depending on how many persons a party is allocated, will take in order of priority. But many of the parties will put persons with disabilities number 6, 7, or 8. Yet they cannot get 8 representatives. Hardly can any party get more than 2 or 3. And so this law means that the Election and Boundaries Committee cannot change that list to say that 2 or 3 parties in one county have nominated a youth or a woman, and so they will have 3 or 4 youth or women, yet none has nominated a person with disabilities because they were listed uko nyuma. So you can find that law that prohibits IEBC from saying you have 2 youth already, so the next one must be a person with disability. That the law prohibits them from doing that. So we need such a law to be reviewed, so that you don't have a county with the 4 representatives of youth, and there is no persons with a disability. So these are some of the problems that we are saying. There are still laws that are discriminatory in one way or the other, or lead to discrimination, and needs to be aligned to the convention, need to be aligned to the general policies of the government. Thank you very much. What can be done? You want to say something?
Yeah, and you see, even as we go on, Sam, what other time is also not on our side. What really compounds all these are considerations of gender, race, socioeconomic and cultural factors that also impact on access to justice. And trust me, most of you seated here know what some of our communities consider disability to be and what they do with children born with disabilities. They will lock them up, they will keep them away from society, claiming that that is a curse or that is, and that compounds the whole problem that we have in accessing justice, in accessing our rights and ensuring that we realize our basic rights and fundamental rights and basic freedom. So there is a lot we have to consider in all this. And how do we go about it? It's all about advocacy. It's all about community mobilization to ensure that we empower our communities to think right. Now, continue, Sam.
Thank you very much. Now to what Dr. Laibuta asked me, what can be done? In my second to the last principle that I put forward was that of monitoring. And in a country like Kenya, we have 2 bodies, actually almost 3 bodies, that are supposed to monitor the rights of every Kenyan. One of them is the Kenya National Commission on Human Rights. We also have the Gender and Equality Commission, and we also have the Commission on Administration of Justice. We would want to know how well these people are working with the people with disabilities, to advise them where they even need to go to court, to advise them on where their rights are being violated, and how well they are working with organizations or persons with disabilities to educate them on these rights and to empower them to demand for the rights. So we need a very close working relationship, and the convention foresaw this very close working relationship between the human rights institutions, because they are independent and their role is to look after the rights, and the organizations or persons with disabilities who are the right holders and whose rights are being violated. So a stronger connection between these 2 is very necessary. We also need a lot of education to the judiciary. I hope my friend here doesn't fight me over that. But he will agree with me. A lot of our judges need to be even educated on the Convention on the Rights of Persons with Disabilities. And by the way, the judiciary has what is it called? An inclusion committee or something like that. I was once told to go and speak with them. And when I went, I was so surprised. It's the junior officers, not even the magistrates. The junior officers, telephone operators and messengers who came. Right. So you can see, how do we reach the real people who need to understand? So these are some of the things that I think we need to do. Also, those of us who have been enlightened, let us be a little more litigative. Where our rights are abused or our colleagues' rights are abused, let us see how we can go to court. So I think that's what I'd like to say.
Thank you, Sam. Just so to conclude, I'm told that our time is up. So to conclude, as you monitor, as you evaluate what your different organizations do, please do it hand in hand with persons with disabilities. Let social media take up this agenda. Let there be, let civil societies also weigh heavily on disability rights, protection and promotion, and let us all join hands to ensure that the rights of persons with disabilities and in particular access to justice is real to all of us. Thank you very much. And I don't know whether we have time for questions or we call it a day.